Hello and welcome to the channel. The Supreme Court yesterday gave its verdict on the old Naira and ruled that it should remain legal tender until the last day of the year. By that ruling, the Apex Court has overruled the president who had insisted that both the old 500 Naira and 1K notes had ceased to be useful, but allowed the whole 200 back in circulation until next month. It is still not clear how this will proceed moving forward, as neither the president nor the CBN governor have made any statement since the ruling. Subscribe, like, share, and comment. Thank you. You disobeyed us, attempted to sacrifice democracy. Supreme Court slams Buhari. The Supreme Court on Friday nullified the ban on the use of the old 200 Naira, 500 Naira, and 1000 Naira banknotes as valid legal tenders by the federal government. The Apex Court, in a unanimous decision by a 7-member panel of justices, held that the whole banknote should remain in use until December 31st. It held that the whole Naira note should be used alongside the redesigned currencies until the end of the year. In its lead judgment that was prepared and delivered by Justice Emmanuel Adjim, the Apex Court slammed the federal government for unilaterally introducing the demonetization policy through the Central Bank of Nigeria (CBN) without consulting the Council of States, the Federal Executive Council, the National Security Council, the National Economic Council, civil society organizations, and other relevant stakeholders. It held that federal government failed to give valid notice to all the federating units before it decided to withdraw the whole banknotes from circulation and introduce new ones. The Supreme Court maintained that evidence before it established that a purported notice on the monetary policy was through mere press remarks by the governor of the CBN, Mr. Godwin Emefiele. It held that such remarks did not qualify as reasonable notice to the states as envisaged under Section 23 of the CBN Act. Besides, the court invalidated the directive President Muhammadu Buhari gave in the broadcast he made on February 16, which allowed only the whole 200 Naira notes to remain a legal tender till April 10. While accusing President Buhari of disobeying the interim order it made on February 8, which directed that the whole banknotes should remain in use till the determination of the case before it, the Apex Court stressed that the president, by going ahead to ban the old banknotes, acted in a way that was inimical to democratic governance. According to the court, having acted in disobedience to its order, the federal government lost its right to be granted audience before it. I agree with the plaintiffs that the first defendant ought not to have been heard by this court when he refused to respect the authority of this court and the authority of the law from which the authority of the president and government of Nigeria thrives. The rule of law upon which our democratic government is founded becomes illusion if the president of the country or any other authority or person refuses to obey the orders of courts. Disobedience of orders of court by the president is a sign of failure of the Constitution, the Apex Court held, describing it as an attempt to sacrifice democratic governance on the altar of autocracy. Earlier, the court dismissed all the preliminary objections that federal government raised against the consolidated suit that 16 states of the federation filed to challenge the Naira swap policy of the CBN. It held that the suit qualified as a dispute between federal government and the federating states to which the Supreme Court has exclusive and original jurisdiction to determine. The court held that the CBN, being an agency of the federal government, was not a necessary party that must be joined as a defendant before the legal dispute could be effectively resolved. In the light of the foregoing, I hold that all the preliminary objections lacked merit and they are accordingly dismissed. The Apex Court ordered. It will be recalled that the states had, through their respective attorneys general, invoked the original jurisdiction of the Supreme Court to nullify the federal government's ban on the use of the whole banknotes as valid legal tenders, though only 3 northern states, Kaduna, Kogi, and Zamfara, initially approached the Apex Court to halt planned full implementation of the Naira swap policy. However, more states later applied and were joined as interested parties in the legal dispute. The states that were joined in the consolidated suit were Lagos, Cross River, Ogun, Ekiti, Ondo, Sokoto, Jigawa, Kano, Rivers, Nasarawa, Niger, Abia, as well as President Muhammadu Buhari's home state, Katsina. Likewise, though only the Attorney General of the Federation and Minister of Justice, Mr. Abubakar Malami's son, was initially sued as the sole defendant, both Edo and Bayelsa states subsequently persuaded the Apex Court to join them as co-defendants in the matter. The two states said they were fully in support of both the federal government and the CBN on the Naira swap policy. Subscribe, like, share, comment, and please turn the notification bell on. Thank you. Meanwhile, in the substantive suit marked SC CV 16223, the plaintiffs prayed the Apex Court to declare that the demonetization policy of the Federation being carried out by the CBN under the directive of President Buhari was not in compliance with the extant provisions of the 1999 Constitution as amended, as well as the CBN Act 2007. They further sought a declaration that the 3-month notice that was given by federal government through the CBN under the directive of President Buhari, the expiration of which will render the whole banknotes inadmissible as legal tender, is in gross violation of the provisions of Section 23 of the Central Bank of Nigeria Act 2007, which specifies that reasonable notice must be given before such a policy, as well as a declaration that given the express provisions of Section 23 of the Central Bank of Nigeria Act 2007, the federal government of Nigeria through the CBN has no powers to issue a timeline for the acceptance and redeeming of banknotes issued by the bank, except as limited by Section 22(1) of the CBN Act 2007. The central bank shall at all times redeem its banknotes. More so, the plaintiffs prayed for a declaration that President Buhari lacked the powers to unilaterally direct the CBN to withdraw the whole banknotes and circulate redesigned currencies. They urged the Apex Court to direct the federal government to immediately suspend the demonetization policy until it complied with relevant provisions of the law. The plaintiffs told the court that there has been an acute shortage in the supply of the redesigned Naira notes in their respective states since the new monetary policy was introduced, adding that residents in their states that complied with CBN's directive and deposited their old Naira notes have increasingly found it difficult to access the new currency to conduct their daily businesses. That's the news, guys. Thanks for listening. Until next time, bye.